Hi, my name is Caroline Marfel, and I'm a 2L here at Queen's Law. Today, I'm here with Professor Lisa Kerr to talk about a very important decision that was just handed down by the Ontario Court of Appeal called R.V. Morris. Mr. Morris is a young Black man who was convicted of possession of a loaded handgun in the Toronto area. The appeal was about his sentence, and so now I'm turning it over to Professor Kerr. What were your main takeaways from the case?
Well, I think the most striking thing about Morris isn't actually what the Court of Appeal did. It's what defense counsel did at the sentencing hearing. So the lawyers in this case filed way more evidence than you usually see at a sentencing proceeding. They brought in a number of expert witnesses who told the judge about how the lives of Black Canadians have been impacted by historic and present day racism. And they connected that collective story to Mr. Morris's life, right? They described the profound challenges he faced as a result of his family background, his negative experiences in school, in his neighborhood with police. And what this all did was really allow the sentencing judge to pay attention to the life circumstances of Mr. Morris in a really deep way, right? To consider him as a person who made choices, but whose choices were shaped by context. And what the Court of Appeal did confirm in its opinion was that this type of social context evidence is not only admissible, but that in many cases it's absolutely essential to obtaining an accurate picture of an offender.
So those are positive and important takeaways from the case, but didn't the Court of Appeal also say that it would have imposed a longer sentence on Mr. Morris?
Yeah, that's right. And the court did think that the sentencing judge got some things wrong. The main thing the court said was that the judge had sort of failed to keep the issue of the seriousness of the offense separate from the question of why Mr. Morris committed it. So the fact that Mr. Morris was carrying the gun out of fear, for example, doesn't mean that it's any less serious of an offense in terms of the risk to public safety that his actions presented. So his fear and his past trauma and those other kinds of factors were relevant to the question of his moral blameworthiness. But the judge sort of allowed that to sort of blur into the question of how serious the offense was. So I actually think in future it should be pretty straightforward for judges to follow what the Court of Appeal has said and keep those things separate. At the end of the day, the court wouldn't have changed the sentence by all that much. It would have substituted a sentence of just of 2 years less a day rather than a year.
And with that information, that means that someone like Mr. Morris could still qualify for a conditional sentence, right? Instead of being sent to provincial jail.
Absolutely, and that's really what is so significant here. By choosing that 2 years less a day mark for the substituted sentence, the court is communicating that it could still be a conditional sentence because it's still a provincial sentence. So that means that strict house arrest is still an option that's on the table for sentencing judges for these kinds of offenses. And that's crucial because it means a judge would have the freedom, if she thinks it's an appropriate case, to avoid sending someone into a really chaotic and destabilizing jail environment. So she'd have that option to keep, for appropriate cases, to keep people under close controls in the community. And in many cases, we know that that's going to mean a better shot at rehabilitation.
That is a positive. This has been so informative, but my last question for you is R.V. Morris ultimately a win for those who care about bringing racial justice into the criminal law?
Yeah, it's hard to say right now. It kind of depends on the mood you're in when you look at the opinion. I think there's a lot in the opinion and in the approach that was taken by the lawyers in this case, which has ultimately been very much vindicated. There's a lot here that's going to help, a lot to build on in terms of making sentencing a sort of part of the legal system that can look closely at who people actually are and how they've actually had their choices and their life opportunities impacted by the societies within which they grew up. And I think that's really important and a good thing and something we can build on.
Perfect. Thank you so much for your time today.
Thank you, Carolyn.